distinct value of justice has been studied by many scholars and philosophers across the globe. Justice, as theorized by Rawls, is what Amartya Sen critiques in Justice and the Word. Justice and the Word is a chapter in the book The Idea of Justice, which was written by Amartya Sen in the year 2009. Amartya Sen is quite concerned with the concept of justice, the notion of justice. Therefore, he presents a very coherent, responsible, and a very deliberative account of justice in this particular chapter, Justice and the Word. According to Amartya Sen, a perfect or an ideal state of justice can never be achieved. And the reason why this cannot be achieved is that there are several perspectives, there are several parochial notions, prejudices, ideas, which do not allow a kind of a consensus. So, while diagnosing the injustices of the word, he believes that one must be very careful about preserving the rigor of careful thinking. One must not talk down to the listener from a height, because one has to think about each and every person of the society. And also, it is an established fact, while doing justice to one, you could be doing grave injustice to the other one. So, justice is equality, but justice and equality are also relative values and concepts. Various theorists of social contract have focused on an institutional arrangement for the society, which is referred to as the transcendental institutionalism. Now, the transcendental institutionalism concentrates on a concept of perfect justice, and it institutes this pattern to a particular organization or an establishment. Amartya Sen believes that justice is no longer a product of just structural relations between economies, but it is rather a product of, or the outcome of, the relationship between individuals. So Amartya Sen tries to construe justice in terms of maximization of liberty, equality, and opportunity in the light of fairness. Though the concept of justice has always been an all-time favorite, whether it is with those who are from the religious order or from philosophy, whether it was Plato, whether they were the utilitarians or Marx, everyone has contemplated and has provided one idea or the other about the concept of justice. The 1990s were the time when justice became a major concern for the developmental studies. So the language of justice shifted away from a structured analysis of dependency on theory to focus on the individual rights and freedom. This particular chapter, Justice and the Word, is a critique of John Rawls' theory of justice. According to the Rawlsian project, there is a social arrangement, a social contract, which he holds as fair. And this, especially in the liberal societies, he says that this is something, the greatest good of the greatest number of people, what the utilitarians were thinking. So two of his books, which are A Theory of Justice, which was written in 1973, and The Law of Peoples, deals with these notions of justice, while The Theory of Justice deals with the notion of justice in the liberal societies. The Law of Peoples deals with the international justice. Now, Amartya Sen brings in new dimensions to our understanding of justice, to our understanding about the well-ordered systems of the world. He believes that justice is to be understood as fairness. He finds Rawls' model of justice very problematic because he says he assumes as if people are born in discrete, self-contained, self-sufficient societies and they leave the world by their death. So the decisions within one society can have effect on serious consequences for others as well. Therefore, he says that we have to go beyond the boundaries. We have to cross the boundaries and think of the whole world as a society rather than just considering one state or one country, nation as a society for the purpose of a social contract. So this is his one of the added dimensions to this. Because Rawls' theory is more about distributive justice and is based on the idea that society is a system of cooperation for mutual advantages between individuals. So it emerged at a time when maximum welfare of the society and the happiness of the majority was the concern and this was taken as a utilitarian concept. So Sen adopts a very transcendental approach to justice for creating a universal account of justice. He is being critical of the ideal theory. He raises his concerns against the establishment of just institutions. In order to do so, he talks about various jurisprudential theorists, as well as he refers to the Sanskrit literature and the ideas on ethics, and also the distinction between niti and nyaya, because both translate as justice, but they summarize rather different notions about justice. Niti, he says, is the correct procedure or the formal rule or the institution. And nyaya is the inclusive concept that looks to the word that emerges out of the institutions that we create. So Sen critiques the conventional notion of justice and he elaborates on the notion of social choice. So every header in this chapter gives the salient features or characteristics or the perceptions of justice that Amartya Sen holds, and he wants the word to adopt those notions. So he insists on the fairness that is to be involved, a reasonable concern for the interest of others. He considers every human capability for a democratic decision discussion. So the idea of justice in a global view gets a very democratic perception as Amartya Sen talks about certain things which he disapproves of when we talk about roles. He says Rawls' approach cannot compare concrete situations with regards to justice. It can also not move beyond the institutions and rules to bring about behavioral realization of justice. He says even Rawls' approach cannot tolerate the assessments that offer only partial just solutions. Rawls' approach can also not avoid parochialism because it is concerned about the deliberations related to only one society, culture, state, or nation. He sets off by making some remarks about the objective analysis of the on justice, and he says that there is a requirement for public reasoning rather than prompt rejection of the contrary beliefs, no matter how implausible those beliefs might initially look, and how voluble the crude and rough protests might appear. Open-minded engagement in public reasoning is quite central to the pursuit of justice. He says resistance or protest is a good thing because resistance to injustice typically draws on two human tendencies, which are indignation and argument. And he gives a heading of wrath and reasoning. And he talks about the positive things about wrath and reasoning. Otherwise, we all know that anger is not a good thing, but he says that whenever you are questioning the hegemonic order or the unequal orders or unjust orders, you have to rationally think, you have to appeal to the reason, even when you are exhibiting your indignation against certain things. So he says that this indignation and reasoning has a dual function. One, that it is bringing out the expression of anger and exasperation. On the other hand, it is also suggesting some ways and means to reach that threshold of equality or fairness, righteousness, or justice. He illustrates this with the example of the pioneering feminist thinker Mary Wollstonecraft, what she a vindication of the rights of women. So he says, even in her radical rejection of the subjugation of women, whatever she speaks or she writes has so much of a confirmation of certain principles or has a respect for reason and not denying the fact that she's loudly demanding justice for women. She's also strongly appealing to reason in her angry rhetoric. And he, in fact, brings out those words that are written by Mary Wollstonecraft. I'm just going to read that out. Let woman share the rights, and she will emulate the virtues of man, for she must grow more perfect when emancipated, or justify the authority that chains such a weak being to her duty. If the latter, it will be expedient to open a fresh trade with Russia for whips, a present which a father should always make to his son-in-law on his wedding day, that a husband may keep his whole family in order by the same means and without any violation of justice reign, wielding the scepter, sole master of his house, because he is the only being in it who has reason. So she clearly, is making a plea and is also highlighting the inequities that are suffered by women and also the kind of treatment that is meted out to the deprived group of people, whether and this is quite comparable to the slaves or any kind of marginalized people anywhere. So her classic writings are based on a strong appeal to reason, and her angry rhetoric is consistently followed by reasoned arguments with which Wollstonecraft wants her opponents to consider the case, right? So in her letter to M. Talleyrand, to whom her book A Vindication of the Rights of Women is addressed, Wollstonecraft concludes by reaffirming her strong confidence in relying on reason. I wish, sir, to set some investigations of this kind afloat in France, and should they lead to a confirmation of my principles, when your French constitution is revised, the rights of women may be respected if it be fully proved that reason calls for this respect. So she is putting forth the claim by combining wrath, and reasoning. So, this is also a pure expression of discontent and disappointment with whatever is existing in the order. But Amartya Sen points out that this kind of an integration of wrath and reason is also contributing to the public reasoning. The appeal to reason in public, on which Mary Wollstonecraft insists, is an important feature of the approach to justice, which he has tried explaining time and time again in this book. So he says, when we try to determine how justice can be advanced, there is a basic need for public reasoning involving the arguments which are coming from different quarters and divergent perspectives. So he says it is quite natural for the divergent perspectives to exist, but that doesn't mean, he says, conflicted reasons are good. There is no need to have a consensus, because out of the dissensus also something democratic is going to evolve, and this will lead to the advancement of justice. He says an engagement with contrary arguments does not, however, imply that we must expect to be able to settle the conflicting reasons in all cases and arrive at agreed positions on every issue. Complete resolution is neither a requirement of a person's own rationality, nor is it a condition of a reasonable social choice, including a reason based theory of justice. In the next section of the chapter, he talks about justice being done, being seen to be done. So he says, he expresses a hope, that whenever justice is to be done, it should be seen to be done. And this is a phrase that he borrows from Lord Hewitt, who in Rex versus Sussex Justices 1924 says justice must not only be done, but also be seen to be done. So he says there should be no botching up, no confusion, no uh, no confusion regarding whatever is to be judged. So he says whenever one is trying to remove a confusion between the legal correctness and popular endorsement, he should go the democratic way. In the next part, he talks about the plurality of reasons. Now he says already he has started a chain of thought which says that divergent perspectives will be there will be a disagreement, and there is no need to have a totally agreed point of view. So now he says that one has to accept the plurality of reasons. Why? Because we all hold contrary notions. It is quite natural to human beings, because we don't all conform to the same thought. And he says, but if you have to have that plurality of reason, then, or the contrariness of reason, then you should have the one that Mary Wollstonecraft had, because he says Mary Wollstonecraft's contrariness was her willingness to dispute, argue, and suggest an alternative, which is the greatest source of wisdom and understanding for anyone, since ages, to comprehend this distinct value of justice. After speaking about the plurality of reason, he then also talks about how there is a need to be impartial in one's reasoning. Now, this impartiality, he says, is objectivity. Despite the fact, now, when we talk about the plurality of reasons and when we hold some plural divergent notions, it is quite natural that we are being subjective. But he says one has to transcend that subjectivity. One has to reach an impartiality of reason for respecting the freedom of others, for respecting the equality of others. So the actual disagreements that exist may be removed through reasoning, It may be helped by questioning the established prejudices, vested interests, and unexamined preconceptions. So he says the plurality of reasons can sometimes pose no problem for a decision, but on the other hand, it can also pose a very serious challenge when no resolution can be achieved. So this kind of a situation is something, he again suggests means to rectify this. He says, then what should be done? There should be a partial ordering of these plural reasons to achieve an impartial reasoning. So there might be many alternatives, but these alternatives might be inconsistent, but still with some kind of clarity, these inconsistencies have to be partially worked out so that it becomes something impartial and objective. And when we have an impartial or an objective view, it is quite natural that this will lead to an enhancement of justice. He then also talks about a comparative framework, because he says that we are not existing in isolation. All we share some kind of mutual interests. So there are some kind of, there is an interdependence of interests, whether it is in the local community or it is in the global community. So again, he quotes Dr. Martin Luther King Jr. when he says, injustice anywhere is a threat to justice everywhere, to bring out the fact that justice is not a justice of one nation, one community, one culture, one society. There is always an interdependence of interests. Therefore, he says, a comparative study has to be made. For example, we studied the story The Bet by Anton Chekhov. And while doing that story, we discussed about the controversies that have been existing since centuries. And if you have to study the controversy regarding the death penalty and life imprisonment again, how has the notion or the idea or the final form of punitive practice decided? Again, there have been some influences from one country or the other, which are responsible for bringing this kind of, uh, say, some kind of a relief to the fact that, okay, death penalty is not always the only way to punish a person, even if the crime is of the severest form, right? Because again, you have already studied Discipline and Punish, where correcting techniques are to be used. Disciplinary mechanism has to be adopted to reform, not to control the body, but to reform the soul, right? So he says, since we are linked with each other, we are interdependent, we have those interests which are related. Therefore, we need to comparatively study this value, which everyone finally fails to achieve because of subjectivity, because of the partial or notions or prejudices and biases that they hold, and they are so strongly anchored to it that they don't want to leave those notions. Then again, he talks about the non-parochial requirement for justice. He says, if you have to understand justice, you cannot limit it or rely on parochial reasoning, which is linked to some national traditions or some regional understanding of the facts. So he says, whatever, we are human beings and we share certain things which we have to, the societies have to come over in order to reach a state of fairness. So he says, he gives the examples of various customs and traditions that are followed and what kind of punishments. For example, in the case of adulterous women, then the case of infanticides, then the case of juvenile crimes, he's talking about that, and he says, while we have to decide finally what is just and what is unjust, we have to scrutinize the systems around us. We have to scrutinize the conditions, and then only can we reach at some kind of a just statement about anything. Now, he concludes this particular chapter by saying that a democratic reasoning is very important because it will enhance the objectivity of any political process or any kind of communication. So the distribution of benefits of the global relations, he says, depends not only on the domestic policies, but also on a variety of international social arrangements, which include the trade agreements as well, the patent laws, global health initiatives, international educational provisions, facilities for technological dissemination, ecological and environmental restraint, treatment of accumulated debts, and restraining of conflicts and local wars. So he says there are many eminent issues which can be discussed for a fruitful global dialogue, which is for say the successful operation of justice all around the world. He concludes the chapter by saying that social contract is not what we require. Transcendental institutionalism is not what we require. What is required is a social choice based on public reasoning, a good reason, impartiality, and objectivity. And how do we achieve that? By transcending all those parochial divisions, by making a comparative framework, comparative study of what's going on where, and also trying to trace the differences and commonalities. And once he says we find these differences and commonalities that are existing in the systems or in the operation of certain institutions, what will happen is that we will be able to reach at some kind of uh, a state where we can actually provide some kind of justice to those who have been deprived of all this. So whatever Sen is talking about in this chapter from the book The Idea of Justice, he is trying to say that only enlightened democracies can achieve this kind of justice. So his contribution to renew the normative economics and political philosophy, he's proposing another way to comprehend justice. So his idea of justice is a renewed theory of justice that emerges from the debates that have been existing. And so he's proposing a concept of capability which centers on the individual and individual's rationality, individual's potential to democratically carry out the agreements or any kind of good that one has to do to the system or to the society. So he opts for a social choice approach rather than of a social contract. And he believes that excluding the possibility of interpersonal comparisons or removing inequality between nations, individuals, classes, or improving individuals morally and intellectually is more important. So no doubt, absolute equality or equal rights of freedom cannot be attained, but an effort can be made. And this can happen through participatory decisions by being sensitive to the heterogeneous interests of a diverse population, and then being very impartial, and then ensuring that the enforcement of the laws and regulations takes place actually, so that there is uh, a kind of a just system that prevails.